Yeah, looks good. All right. So, welcome everybody. I'm so glad you're here. My name is Fatima. I am an attorney based in Chicago. I had a practice formerly that focused on community development through the verticals of intellectual property and cooperative development. Now I'm in-house at a non-for-profit and trying very hard to balance my lawyer identity with my operational identity. Some days doing a better job of that than others. But I'm really glad to be here. I am a bit intimidated by the task at hand because 8 minutes is absolutely nothing. So I want you to know that I've given some thought to these slides. There are a lot of different things mentioned, but we won't be going particularly deeply into any of them. That being said, I think if you know kind of the gist of what's on each of these slides, you're in a really, really good place to start thinking of yourself as a copyright practitioner. So I definitely welcome questions. And yeah, before we dive in, I will ask that you just hop in the chat and you let me know what your comfort or experience level is with copyright law. USPTO website is a good place to start. I like that. Hope you could probably be giving this presentation instead of me. Feel free to correct me if I say anything wrong. Awesome. Beautiful. Thank you. Cool. All right. In that case, I feel like we have a good grounding to start with, which is, I think let's start by just talking about copyright and how it fits into the overall IP landscape. Forgive me for starting super, super basic, but I think it'll be a good foundation for us to start with. So next slide, please, Hope. Next slide, please. Intellectual property, what is it? It is, in the abstract, the concept of property that is not tangible, that is intellectual in nature, go figure. And in terms of how we've decided societally how to categorize it, generally we have three different legal buckets in the United States. We have patent, we have copyright, and we have trademark. And at a very basic level, these are distinct buckets. Once you start becoming more nuanced in your understanding and utilization of these tools, you realize that there is some cross-pollination among these categories. Next slide, please. What is included in the IP toolkit? There are actually other forms outside of those three that I mentioned, which are federally protected areas. There's trade secret, there's trade dress, rights of publicity, there's state trademark law, which can complicate things a little bit. But the thing to remember is that every form of intellectual property, it has similarities in terms of how these rights are achieved and what you can do with them as compared to other types of intellectual property. But there's typically a different office that you deal with in terms of gaining these rights, and you have different particular rights that accompany each type of intellectual property. Next slide, please. Next slide, please. Why on earth do we involve the government in this process? Aren't ideas just ideas, and shouldn't that be enough? Shouldn't that be the end of the road? Maybe. What's interesting to me about intellectual property is that really it's meant to be a societal incentivization mechanism. When our country was in its beginnings, the folks who were decision makers decided we want the brightest and the most creative people to be part of this country. And so we want to incentivize them to come here. And being American, we said, how do we incentivize people? We give them money. So we said, if you come here and you invent something, not only will it be protectable as intellectual property, but it will be exclusively yours for some amount of time. And in that way, you can profit off of it individually and exclude other people from doing so. I think it's an open question whether or not we incentivize creativity through monetary means. It's something that I grapple with as an intellectual property practitioner. But so you know, this is the context in which we operate, and this is why the United States has these offices, the USPTO, the US Copyright Office, that performs these functions. Next slide, please. And why on earth involve lawyers? The truth is, like most areas of law, people could self-help, but there's something to be said for working with someone who has experience, tools, pattern recognition in particular areas of law. When you seek to obtain rights, whether they be in copyright, trademark, or patent, you effectively engage in a negotiation with a government office. And this negotiation has certain protocols and certain rules that you have to follow, and weird words and things like that, that it's just helpful if you have an attorney who knows that language and knows that process to guide you along. It tends to be a more efficient use of time and resources. Next slide, please. Types of IP. We'll go through these super quickly. Trademark law. This is all about branding. Next slide. Patent. This has to do typically with inventions and also sometimes horticulture. Next slide. And then copyright, the meat and potatoes of today's presentation. Copyright, we're thinking art, we're thinking something that's written down, we're thinking software code is also included here. Basically, forms of artistic creative expression that have been fixed into a tangible medium. And the reason I emphasize that point is copyright has to be more than just an idea in your head. If you have an amazing idea for a book, you can't copyright it. You can copyright the actual book, though. If you have an amazing idea for a song, you can't copyright the idea, but you can copyright the actual song. Next slide, please. Next slide. Oh, the slide just before this, please, Hope. So there are very few black and white rules in the law. Where there are such rules, I tend to emphasize them for the sake of psychological safety. So we have one in copyright law, which is what is the duration of copyright protection? And for works that are created after 1978, it's the author's life plus 70 years. Or if we're talking about something that was made within the scope of someone's employment, then it's 95 years from the date of publication or 120 years from the date of creation, whichever is a shorter period of time. Next slide, please. Digital Millennium Copyright Act. So I mentioned this. This is one of the multiple roads that we're going to pass by, wave down, but not go down in this presentation. But these are things that I want you to be aware of. The Digital Millennium Copyright Act exists because with the advent of social media in particular, there were a lot of creators whose work was being used without proper attribution. So the DMCA is a federal law that basically created methods for folks to be able to, methods and standards, so that creators who felt their works were being used without appropriate permissions could report those uses to the platforms, Facebook, Instagram, YouTube, whatever it might be. So every one of these platforms has somewhere on the site information as to how you can request a takedown, and that is all dictated by the DMCA. Next slide, please. Open source software is a huge area of interest of mine, one that I have yet to fully explore, but I mention it particularly in this context because it is culturally very distinct from a lot of other areas of intellectual property law. As I mentioned before, the ethos behind intellectual property law is we want to own things. We want to prevent other people from using them. We want to individually exploit the fruits of our intellectual capacity. Open source is a culture within software that is diametrically the opposite of that. It is the idea that we make everything available to everyone to use, to modify, to redistribute. It is rooted in sort of two different schools of thought. Some people subscribe to this philosophy because they believe inherently you can't own an idea and creativity is meant to be shared. Other folks subscribe to this philosophy because they believe actually you get the best product when you have the laboratory of ideas at play, and you have multiple people playing with these things and changing them and using them for different purposes. So there are actually some large corporations that subscribe to open source software for methodologies for that reason. And in general, from what I've found, software developers tend to be very expansive in their frameworks and in the way that they think about sharing knowledge and sharing ideas. Next slide, please. Copyright and AI. This is a fascinating subject and a subject for which I have no answers for you. And if you get a question on this, you can say, we don't know yet, it has yet to be litigated, but it is fascinating. And hopefully this is a road we can go down further. Some really interesting questions that are being posed in this space right now are, can you copyright AI generated content? If so, who owns it? Is it the individual who engaged with AI? Is it the creator of the AI? Is it the creator of whatever materials AI used to compile the response? And also, how do you monetize these things? Copyright is just the first step, right? It's how you capture and define what it is that's been created. But then if you want to license things, if you want to parse out the rights and give them to different parties, how do you do that? These are all questions to which we do not yet have the answers. Next slide, please. Joint ownership. I have 2 whole slides on this because it is something that comes up often in the context of copyright practice. Particularly, it is the source of a great deal of conflict. Joint ownership arises when multiple parties come together and each create or contribute meaningful creativity to a project. When this is the case, you have multiple authors to the work that's developed as a result, and each of those owners has their own rights. Each of those owners actually have full rights unless there's been some sort of agreement on the front end that precludes that. So that means if you have 2 authors of a single work and one wants to license their scope of rights to another party without the permission of the other author, that's possible. So these are scenarios that you often see where simply because of a lack of understanding or a lack of real meaningful conversation between the authors on the front end, these things can get a little hairy. Next slide, please. Here are some common scenarios. Again, when multiple individuals contribute creatively to the production of something, when people produce something within their scope of work and there's not necessarily a contract in place that dictates what the employer owns and what the employee owns. And also if you do have joint authorship, there needs to be, or if there isn't a clear understanding as to how each individual can leverage their rights within a work, it can be the source of conflict. Next slide, please. The Copyright Claims Board. I wish I had more data on this to date. I don't. If I do another 8-minute presentation, maybe I will, but this is why it exists. How many people do you know, perhaps artists, whose work has been exploited without their permission, without proper attribution, and they feel as though there's nothing they can do about it? Because what are they going to do? Drag someone to court, hire a lawyer? Do you know how much money that costs? Do you know how many years that would take? Understandably, there are very practical limitations to leveraging the judicial system to protect your creative rights. And so the Copyright Claims Board was established to alleviate this issue. It was established fairly recently, within the past decade or so. It is effectively a small claims court meant specifically and exclusively to address copyright claims. It has relaxed procedures, as would normal small claims court. It's limited to matters that are that have damages amounting to $30,000 or less. All parties must consent in order to participate in a matter in front of the Copyright Claims Board. And there's also opportunities for things like mediation, settlement, all those alternative dispute resolution mechanisms are also made available through the Copyright Claims Board. I don't know how heavily it's used. I don't know how successful it is at actually alleviating the issue that I raised earlier. I think that has yet to be fully understood and fully investigated since the inception of the board. Next slide, please. Tools for legal analysis. So A lot of you may stick around and provide some counsel to organizations after this presentation. And so I want to offer you a couple of resources that may be helpful to you. One is the Copyright Alliance. This is a nonprofit organization that represents the rights of creators. If you go to their website, they have a lot of educational materials. They have a lot of, I think they may have like videos, tutorials, all kinds of great things. And they're all very plain language because they're meant to be for creators and not necessarily for attorneys. If you're anything like me, those are the places I go first to learn because I have a human brain and not a lawyer brain. So I find those sorts of resources to be extraordinarily helpful. The other thing I want to say is the US Copyright Office, when it hires copyright examiners, each examiner gets what's called the Compendium of US Copyright Office Practices. This is the manual that people get, and this has all the rules that might pertain to the decision-making process of whether or not something can be copyrighted. This manual is made open to the public, and so it's a phenomenal way to perform research, again, in materials that are fairly straightforward, fairly plain language, without having to necessarily parse the statutes themselves. So the first thing I would like you to do before I go to the next slide is Google the Compendium of US Copyright Office Practices and download that. And now we'll go to the next slide. Oop, there we go. Once you've downloaded the compendium, I want you to access a platform called Charlie AI. This is an AI tool that is specifically meant to take very long, dense research materials and allow you to search using plain language questions really effectively. It's basically Control F on steroids. So if you upload the compendium to Charlie AI, you can interact with Charlie and ask it questions, and it will use the compendium that copyright examiners use to help you find at least the area, the portion of the document that may be relevant. So this is obviously not a replacement for legal analysis, but in the world of copyright, particularly if you're new, if you just want to orient yourself and you want a plain language way outside of Google that's a little bit more precise and a little bit more enclosed to do that, I find this to be very, very helpful.